less expensive and a quicker way to get something on file. Ultimately, you're going to need to file what's called a non-provisional, which is the main patent, and that would have to be filed within a year of the provisional filing. So you get your application filed, now it gets examined. So the patent office, it could be a year before it gets examined, it could be 2 years depending on the technology, and they'll look to see whether you satisfy the requirements. Is it patentable subject matter? And for abstract ideas, articles of nature are not something you can patent. A discovery, that's existed in nature. It might be great that you discovered it. No one's ever discovered it before, but it's not an invention. There has been some changes in the law. The Supreme Court has issued some decisions which is making this patentable subject matter sort of a difficult threshold to meet for certain software. Software patents can be, especially if they're business methods and things like that, are under a lot of scrutiny these days. So, and as I said before, you have to be novel and non-obvious. You have to be different than what's out there. And then, so the whole process to get a patent could be, could take a couple of years. All right, so you obtain patents. You want to get that competitive edge. It's an asset. You can borrow money on it. You can get secure loans. You can prevent competitors from trying to get into the niche of the market that you're going for. So just for patent considerations, document your work. So you know who's inventor, you know what you did if you're working on something. Resolve ownership issues early. And file before you disclose. And also you can do a foreign filing, right? Because patents are geographical. Once you file either your provisional or a U.S. patent, you have 1 year to file abroad, and that you get it's called priority. You can get the advantage of that earlier U.S. filing date. So those are things to think about. All right, another way to protect maybe your edge is with your trademarks. Maybe you have a business that's necessarily not patent. Or maybe you do have patents, but what a trademark does, it's any device, any symbol, any sound, even a smell, but what's important about it is it identifies a unique source of the goods or services. So when people see that or sense that symbol or device, they're thinking that this is coming from a particular source. They might not know what the source is, but they know it's coming from a particular source. And once that happens, you're at trademark significance. Trademarks protect your goodwill. So you're coming out with a product and you're selling it, you put a lot of money into it, it's getting good traction. You don't want somebody to come out with a similar mark, confusing people into thinking it's your product. Because if their product, you make a skin lotion, they use a product, they think it's yours, they put it on and they get a rash. They'll be like, no, I'm never going to buy this again. I'm not going to buy it. And it could hurt you. So you could lose sales. You could lose a lot of sales, and you don't even know it. These people aren't going to call you up and say necessarily, your product gave me a rash. They'll just never buy your product. So goodwill is a very important thing. It's what you're striving to develop, and trademarks help protect that. All right, we have one thing I also want to say. Trademarks, you register a trademark. So I don't know if anyone's been through the process, but you can obtain a federal registration of those rights. Now, you get the rights through use. You've used the mark, you get the rights in the mark. You don't even need to register it. Registration has some significant advantages, but when you put any device symbol out there that's identifying your goods, that is acting as a trademark, and you have federal rights in that. You bring a lawsuit, you have legitimate, it's right in the code. Registration gives you other things. The R in the circle, you see that's only for federally registered marks. Anything else, though, you could do a TM for trademark or SM for service mark. For instance, like a restaurant would be a service, or FedEx is a service. Trademark is usually for goods. Although we use the term, and it's used a lot, trademarks is sort of the broad umbrella for all types. Okay, so we said some examples. Boar's Head would be a trademark. We have FedEx service mark. Then there's some other certification and collective marks, which are kind of specialties. UL would be a certification mark. It means that You have to have met certain certification requirements in order to use it. Talk about trade dress. Trade dress is what the product looks like, so a product design, store design, something, again, it can be really anything that identifies a particular source can act as a trademark. For instance, like the shape of the Coke bottle, that's a classic, it's considered a container, and that's a classic trade dress. All right, so that's your trademarks. The trademarks help protect your identity. Now we come to copyrights. Copyrights, they protect works of authorship. And again, that could be literary works, which include your software. That's another way. Patents are one way to protect software, and copyrights are another. A copyright doesn't protect the idea. It's only the expression of the idea. So, for instance, if you have a software, a web page that has a different, kind of an interesting way in which information should be collected or used, or you can protect the way that looks, but you can't protect the actual underlying idea through copyright. But the software, manuals, marketing material, web pages, they can all be protected by copyright. Now, copyright is something that you get federal copyright protection on the moment you fix the work in a tangible medium. You don't need to register anything to get that right. You don't need to do anything. You get that right by active in the law. So, but you need to create it and you have to fix it. So fixing it could be if you obviously write it down, even if it's on a hard drive or it's a screen, anywhere it's not just spoken word. Like, for instance, if I'm just speaking and not writing it down, it's being taped. So that actually, by being taped, is now fixed. So that's copyrightable. Okay, now these rights can be registered. That's why they call it a registration. It's not like a patent where the patent gives you that right. Without the patent, you don't have it. But a copyright registration is simply registering that mark, or that right, excuse me. And it can be very important. In order to sue in federal court, you need to have a registration. You get statutory damages. You have to have the registration or the application on file before the infringement begins. And you can get attorney's fees in sort of egregious cases. The statutory damages can be nice, because in the statute there's a range of money that you can get if you're infringed. And let's say you have a work that's not necessarily commercially viable. It's hard to put an actual damage on it, but the statute helps you there. And that can give you kind of a hammer to go after somebody who might be taking your stuff. Ownership is very important. I just want to go over this. Again, just because you pay for it, we see this in software all the time. If you go to an outside software developer, they do the work, everything's going well, and now you want to get something breaks off, you want to get the object or source code from them, they don't want to give it, they say they own it, and they own the copyright on it. So make sure anytime you go outside to develop it that you get an agreement, and that you own that. So, and then the last thing I wanted just to generally speak of is trade secrets. Trade secrets are another way to protect your competitive edge. Now, if you're doing something as a process, or you're manufacturing something that would be very difficult to reverse engineer, now you have to make the determination, do I want to try to patent it, because now I have to tell everybody what I'm doing, or do I want to keep it as a trade secret? So it may be something that you've been doing for a while, you can't patent it because you've been using it for more than a year, therefore you're barred from getting a patent, but if you've kept it secret, you might be able to stop others. Now, the trick so a trade secret could be a formula, manufacturing process, it could be a list of customers, it could be a commercially type of thing. And the most important thing with that, though, the court is not going to protect your secrets or give you more protection than you do as a company. So, if you want to protect something, you only, it's sort of a need-to-know basis. If it's an important ingredient on how to make the product, maybe your salespeople don't need to know that. If it's a customer list, maybe the people manufacturing don't need to know that. Have agreements with your employees or people you're dealing with to say it's non-disclosure. And so again, limiting protection. Again, once it's out there in the public, it's gone, you've lost it. So, that concludes the whirlwind tour of intellectual property and ways to try to protect your competitive edge. Any questions? Let's start here.
Yes, sir. Once you file an application for a patent,
Right.
It's a review process. If you have any rights, that's one of the review process.
No, the question is, do you have any rights when a patent is in the review process? Generally, no. However, there is, after 18 months after filing it published, you do get a publication. And if the patent ultimately issues with claims that are substantially the same as were published, you may be able to go back to the date of publication and try to get damages from that. But if your patent never issues, then you have nothing. So that would be sort of, generally you don't, you can say patent pending, as soon as you file an application you can do that, but you know, again, your rights are sort of limited unless you actually get something granted. So in the back, you had a question?
Yeah, going back to the one-year timeline, can you elaborate on the word disclose?
Well, that's a great question because it's, for instance, Europe has going to have a different standard than, let's say, perhaps the United States. When we're looking at it as a patent attorneys, we're of course very, very conservative. So it would be disclosed anywhere that could be public, whether it's at a trade show, whether it's to potential buyers. One thing that's going to be an issue is whether or not, if you make an offer to sell. So if I have a product ready to go and I make an offer to sell and I say, well, it's going to cost, you have $500 a unit or whatever, that's going to start, definitely going to start the time running, even if they don't even know what's inside this black box. So it's a good question. It can really depend on what jurisdiction, but in the United States, it really, the way you look at it, are you disclosing it to someone who doesn't have an obligation to keep it secret? And you can use something called non-disclosure agreements in order to try to protect that. But a lot of companies won't sign non-disclosure agreements, so they'll say, well, rely on your patent rights. So we would suggest try to get even a provisional on file, so you have at least your foot in the door there, and then try to go forward. But your disclosure, that's what, it's a tricky question, and it can be devastating if you don't follow it. So that's something you really should seek, advice of an attorney on if you think you're going to take.
Related to that, how does the one-year grace period relate to the phrase first to file?
Well, in the United States, you now have a first to file system. So it's whoever gets to the patent office with their invention. If two people working in their garages, same idea, they don't know each other, they didn't copy anyone, and one guy invented it maybe a year ago, but he's been tinkering with it, whatever, and this other guy invented it 6 months ago. He gets to the patent office first. If they're trying to claim the same thing, the guy who got to the patent office first is going to get it. Now, the 1 year grace period, you get 1 year grace period based on your own disclosure. So if I disclose something, I have 1 year to get it on file, my patent application on file. If I do, my disclosure can't be used against me. But if someone else, in that 1 year grace period, someone else discloses that same idea, that can be used against me. So the grace period is not an absolute period that protects you from all prior art coming within that 1 year. It only protects you from your own disclosure. Yeah?
With non-provisional patents, you have an idea you file non-provisional. If after that year, exactly that year's term, the funding move forward with it, it didn't convert it into provisional patents, what happens to all that information you submitted, the concept itself?
Right.
Is it public at that point, or is it say private?
If you file a provisional application, okay, you have the year to file the non-provisional. If you do not file a non-provisional within the year, it remains secret. It is not disclosed. The application expires and it is not available for the public to see.
Are you barred from
No, you're not. No, I've done that actually recently. You're not barred. That's not going to be a bar. Now, you don't have the date, so whatever your new filing date is, any prior art before that could get it. Sir?
On the copyright, can you go a little bit, when you have copy, let's say a book or a paper, you publish it, the difference between registering and not registering, is it damages when you file for damages?
Yeah, well, right. So if you register, first of all, if you want to, if someone copies it and you want to go after them, you have to file an application for registration. You can do it, you could wait until someone sues or someone infringes and do it and file, but if you do that, then you're not going to be able to get statutory damages or attorney's fees. You could, in an egregious sort of willful copying case, You can still get actual damages if you prove you've been harmed, and you can still get an injunction. So that's why you still have the right. It's a meaningful right. It's just that you lose a little bit. The government wants you to register them. They really want you to, and that's the reason why they do this. They want you to get your file and register for your work. So,
Thank you.
yes.
Does the idea, this is the last question, by the way, sorry.
I'll be available after lunch or something. If anyone has any questions, and please feel free to grab me. So, yes.
Does the idea have to be actionable today? Not that I do it. I know that I come up with an idea and I don't have to follow through, but does someone have to have the ability to follow through? I think about people, you just had a thing this weekend about the trolls out there. They come up with these ideas, say they had these ideas, somebody else then makes a big business about it, and then they get sued. And say, I had that idea way back when, and here's my patent. But the technology didn't exist. Jules Verne. If we patented a rocket ship, would he say, I thought it would first?
Well, your patent application has to be what we call would be enabled, meaning that